Hey everyone, welcome to Law Chat 101. I am Girija Patel, your legal BFF. Today's topic is going to be about memberships and the law. What do we need to get done? Specifically today, I'm actually going to talk about your contracts for your membership programs that you might have. So if you are a coach out there, or if you have a subscription box or something else in your business model that requires some sort of membership, tune in now. And again, share this video with others that just might find it helpful. If you like it, leave a comment, subscribe so you don't miss out on the next tips that keep coming your way. And of course, before I start, I have to give my disclaimer, which is that I am a lawyer in Houston, Texas, but I am not your lawyer. And if you want to hire me or anybody else, then you have to sign a contract. But until then, this information that I'm sharing with you is for educational and informational purposes only, because it can apply to you, it can apply to many other industries and businesses as well. So here we go, let's get started. So you are starting a membership program, or you've already started a membership program, whether that's a subscription box, whether that is in your industry and a photography membership program or an event planner membership program, whatever program that you have, you should have, number one, a contract. Now, whether that contract or the membership information is sitting on your website, and most likely it is, then there's a couple things that we need to cover for the website, but then also for the contract that you have. So I'm kind of going to talk about those two main things because that's really where you're going to be seeing a lot of the legalities that you need to get done. Not to say that you don't have to do other stuff, but these are some things I'm going to be highlighting today. So when we talk about membership programs, generally you're selling them online because everyone has a website, hopefully. And if you don't, then we should have a separate conversation about that. But you probably have a website and your information is sitting on your website. Your website is your home. It is the home for your business. And so when people come in, they're looking at that website and they're getting all the information. Now, whether you are in the health industry or whether you're in the legal industry or accounting industry, or whether you're in the event industry, photography, wedding planning, venue, anything, you want to make sure that the information you're sharing is pretty clear and concise to what you are offering and the deliverables that you're going to be giving. But then also make sure you have your disclaimers out there so that people know that, for example, if they're getting into a health membership program or a nutritional membership program, what does that mean? Are you a doctor? Are you a certified nutritionist? And if you're not, or if you're not giving information in that capacity, you need to put that disclaimer out there. That disclaimer needs to be in your terms and condition, but also I would just kind of make it very apparent for the big disclaimers just so that people are aware of it. Because a lot of times, let's be honest, nobody brings those terms and conditions. We have them there, we want them there, we encourage people to read them, but not a lot of times people read them. So if there are points of contention in your membership where you have maybe gotten feedback from your clients or your past clients that, hey, listen, I thought it was supposed to be XYZ and it's not XYZ, and yet those expectations are always going to be there because of the nature of your membership. Put those disclaimers out there, put in there so like as a little asterisk, as a note, and then have your terms and conditions sitting right there next to it as well. So that way you're showing transparency, you're being clear and concise, and you're not misleading somebody, because man, oh man, that can be a big problem if you get enough people who feel like you're misleading them. So have the information on your website, but have the terms and conditions that really lay out the membership. And then also you have the big points of contentions or information that could be somewhat misleading, maybe not, or maybe, or assumed incorrectly. Put those out there in a way where they're easily accessible, but also where it's just obvious. Like there's just hardly any way to miss them. That's just a good practice. You don't have to do that legally, but it's a good practice to do, right? And we're all about good practices. We're not just about covering ourselves legally, but we're about good business practices. And so those are some ways to do that in your business and on your website. Now, another thing that you want to be a little bit aware about with regards to your membership and your website is that the terms and conditions should be in a point where they have read it before they sign up for the membership. So have that be an affirmative action. Have it be maybe even something where, I don't know, have you signed up for those waivers where you're signing away your life? And you have to go through, like Apple even, you have to go through everything before you can even say yes. And so that might be something you want to do, especially if you're in an area of health, or you're in an area of finances, or something where people might be considering you to be someone of an expert, or somebody who might have some type of professional credentials. And so just to protect yourself, have those, affirmative terms and conditions agreements out there, and just make sure people know that what you're promising them or what you are going to be delivering them versus what you're not. And don't guarantee something that is not going to happen. So that kind of takes me to our membership contract. And membership contract, some people actually have that on their website. It's living on their website as well, because if somebody wants to sign up, then they need to sign up for the membership contract. And so if you have it where it's automated, it's virtual, the membership contract, of course, should have how long the membership subscription is, number one, the term of the subscription itself, and is it renewable, or is it auto-renewed, or is it something that just cancels itself out and you have to redo the whole process again? Make it clear, especially if it's auto-renewed, make that abundantly clear as well. Number two, you want to have the deliverables. What are you giving to your clients? How long, of course, the term, but in that term, what are you giving to your clients? Are you giving them one-on-one coaching? Are you giving them group coaching? Are you going to be, turning around and talking to them about certain types of milestones that are expected? And what are the deliverables? Are you giving them workbooks? Are you giving them videos, tutorials, a vault that they're going to be accessing? Put that all in your contract, put that all in your membership agreement, because that way people know what they're supposed to be getting, and it's kind of out there. Number three, you want to have your payment. How much of it is it a per month? Is it annual? How you're going to be charging them? Is it auto pay? And so you also want to have in there that they're saying okay to auto payments, that they're saying okay for you to charge their credit card automatically without their approval every month, because right now they're giving you that approval. So you want to have that out there. So you have the terms, you have the deliverables, and you also have payment methods and auto payment, or if it's not auto payment, are you invoicing them, and what to expect in that situation. Number four, what you want to have are disclaimers and disclosures. And what that means is that you are telling them, hey, listen, we might be doing this health coaching. You might be in a health coaching program with me right now, but I'm not going to say that I'm a doctor. And whatever information I give you, I want you to take it, but I want you to seek professional advice before you run with the information that we've talked about. Similarly, even with any other type of coaching, you're not wanting to guarantee any type of results. And so that absolutely needs to be there. So you need to have a disclaimer of any type of professional advice that you might be giving, especially if you're not a professional or do not have the degrees or the certificates to be that professional. Make sure that disclaimer is there, i.e. you're not a doctor, or you're not an accountant, or you're not a lawyer, or you're not a nutritionist or a therapist or a psychologist, whatever. Give that disclaimer out there depending on the nature of your business. And then another thing that you want to do is say that you're not guaranteeing any results. Of course you want to see your customers thrive. Of course you want to see positive outcomes. But you just don't want to promise it. You just don't want to guarantee it. Because honestly, group coaching, group membership programs, a lot of it is not just the coach or the business providing. You can give all the services and the deliverables. But if your client is not taking it and implementing it and executing it correctly, the results may not be what you want. And so you don't want to promise something that you just can't control. And so you want to make sure that you're not guaranteeing any results, but you are just saying that we're here to see you succeed, but we cannot guarantee you any results. Doesn't matter what area of business you might be in, or what industry you're in. So make sure you have those in there so that it's abundantly clear and you're not promising anything, because that would just be the worst, is to promise and to guarantee and not be able to see it happen. And so those are some of the most important things to have in your contract. Now, another thing that you want to have in your contract, number 5, is that you want to have your termination clause in there. And is your termination just whenever they want to terminate or whenever you want to terminate. What does that mean? Is there something that could trigger a termination? Is there something where they have to give you an extra so many days before something is terminated, before the agreement is terminated? So give them a precise outline of what termination looks like when can they terminate, how can they terminate, and what do they need to do to notify you? So there goes to the notice factor of your contract, which is essentially you need to have one. If you don't have one in your contracts, you need to have a notice clause, because notice actually tells or allows you to tell the other party when something material is happening in that business relationship, and it's going to be impacting that agreement that you have. So notice kind of gives you the way to let them know, and also the timeliness of letting them know. And so you want to have the termination in there and telling them what triggers it, if anything triggers it, or if it's just like, hey, I don't feel like doing this anymore and you can cancel it anytime. Perfect. Write that in there. It's really what suits your business model and what suits your business that matters. And if you need them to let you know 15 days before the next month starts or the next billing cycle, then that also needs to be put in there. So that way your logistics and your operations are running smoothly. And so there's a lot that goes into this. It's not just I feel like this, but really you have to look at your business and what's really working with your business, logistically, what's really working with your business, and also strategically, and also the operations. How does it make it smooth? So these are some of the big things that we need to have in our membership agreement. And the membership agreement also, there are things like the force majeure clause, which is, of course, post 2020, everybody knows about that and everybody understands the value behind that. So you want to have that as well. Another thing that's really important before we wrap it up today is assignment and transferability. Can this agreement be assigned to somebody else? Meaning, hey, I don't feel like doing it, but my sister wants to do it, so I'm going to assign it to her. Are you going to allow that? Or are you going to allow it if you give permission to it? And then you can have that in your contract that assignments aren't allowed unless the company agrees to it in writing. And then also you want to have whether, assignment is one thing, and whether you can transfer it, same thing as assignment, whether you can transfer it to somebody else. And so those questions are, does it work for your business model or doesn't? There's no right or wrong answer, but it just means that you just have to see what works for your business, and then you take it from there. So I hope this was helpful. If this was helpful, leave a comment, let me know, share this with somebody else, subscribe to Law Chat, because not only do you get amazing tips, but also you get some great Law Chat podcast episodes that come out every Thursday. And that is essentially mentorship through storytelling. It is beautiful. I have some amazing guests that come, share their journey, share their wisdom, their challenges, and then how they triumph. And it is just so exciting. Every single guest is awesome. I am so happy that you tuned in today, and I am looking forward to seeing you later. Bye.